Well, welcome back to the Cordell Cordell Town Hall. I'm Scott Trout, CEO and Managing Partner of Cordell Cordell. And as always, I'm here to moderate the topic for today and this month. And we're going to be talking about how to toughen up your case by using experts. You know, over the course of the last year, we've talked quite a bit about expert testimony in our podcast. We've referenced it in some of our virtual town halls, but we've not dedicated just a sole town hall to podcast or to experts, which we'll do today. And we're joined by a large number of Cordell Cordell partners, an entire group of partners for our panel today as we talk about experts, which is such an important topic. But remember, today in our second half of our town hall, as we always do, we allow you to ask questions. Submit those live and we'll get answers of our panel today. You want to do that in the Q&A section of the Zoom. So Q&A, submit those now, and we'll get to those in the second half of our town hall as we progress. We have a new email address for questions that you want asked either in a podcast or if you want them asked later, just not today, but you can do that at townhalls@cordelllaw.com. townhalls@cordelllaw.com. We're out of the COVID pandemic as we focused over that in the last year, and most of our town hall was premised upon how to respond to it as we continue to exit from that. We're now just transitioning in for guys how to deal with those issues before, during, and after divorce. So again, townhalls@cordelllaw.com. Remember, as I always indicate, this cannot be a substitute for legal advice. It is not legal advice. We don't want an attorney-client privilege relationship established. It is not. Obviously, the facts, the circumstances of your case are very unique and very specific, and only advice can be given after a consultation. And we're available around the country, as you'll see from our panel. We have a diverse group from around the country, and we have offices in the UK. If you'd like a consultation, you can do it via Zoom. You can do it via phone. Microsoft Teams, whatever platform you want to use, or you can come in person where it's appropriate and where you feel safe. But you can give us a call, 866-DADS-LAW, or go to the web, cordellcordell.com, but also check out all of our material on our YouTube channel, where we have things like this, as well as our podcasts, and subscribe to our podcast. You'll get updated when a new podcast is dropped. Just 15 minutes, real the highlights of specific topics for guys before, during, and after divorce. So let's go ahead and introduce our panel of Cordell Cordell partners for today's town hall, starting out in Kansas City, Missouri. Welcome, Kim Gray.
Hello, Scott. How are you?
Doing great, thanks.
I'm Kim Gray. I've been here with the firm for 11 and a half years, and I'm currently working out of the Kansas City office.
Thanks, Kim. Let's go to Omaha, Nebraska with a management partner, Jerrad Ahrens.
Thanks, Scott. I've been with the firm about 10 and a half years now, and I currently manage our Nebraska, Iowa, Florida, and North Carolina offices.
All right, Jason Lasser, partner in Pittsburgh. Welcome.
Thanks, Scott. I've been practicing with the firm just over 11 years. I've been practicing myself for 13 years in total, and I manage our Pittsburgh office and most of our offices in the Midwest, Ohio, Louisville, and Minneapolis.
Thanks, Jason. Going to Dorothy, who's currently a partner and in Ohio, but relocating to our Colorado offices. Welcome, Dorothy Ripka.
Thank you. Hi. I've been with the firm for 18 and a half years. I've been practicing for 20, and I am distinguished because I have practiced in practically every state. Just kidding. But I'm licensed in 5 states.
Definitely have been around the world when it comes to Cordell offices. So a new partner, Tomekia Lee-Chaney, down in Dallas. Hope that everything's warming up down in Dallas, but welcome, Tomekia.
Thank you. I appreciate it, Scott. I am a litigation partner here in our Dallas office. I am board certified in family law by the Texas Board of Legal Specialization. And I'm happy to be here with you today.
Thanks, Tomekia. And rounding out the panel for today of Cordell Cordell attorneys is Jill Massey, litigation partner in Atlanta, Georgia.
Hey, Scott. My name is Jill Massey. I am in Atlanta, as Scott said. I am with the firm now for 8 years. I've also been practicing exclusively in domestic relations for 8 years. I'm licensed in both Georgia and Kentucky, which is not nearly as impressive as Dorothy's credentials.
Yeah, not many people have been through that many states and relocated. So, well, that is our panel for today, as you can tell. We're bringing you some of the best that Cordell and Cordell has to answer your questions. So submit those in the Q&A section as we go along. We have some questions that we'll cover already in the second half. We're going to talk a lot about experts. So get some paper, get a pen and pencil out, take some notes, and then submit questions if you don't want them addressed today at townhalls@cordelllaw.com. Check us out, cordellcordell.com. We're going to get started here shortly. We'll be right back after this brief break.
For some dads out there, the coronavirus pandemic has become a pretext to limit access to their children. Other dads have been pushed out of key decisions affecting their children's lives. If you're one of those dads, Cordell & Cordell is here for you, as always, but with expanded services. We can meet you in person or by video conference on weekdays, evenings, or weekends. Our goal is to step up our service to meet your needs now.
Well, as I mentioned, we're available. And during this pandemic, as we roll out of it, and some parts of the country still have some restrictions in terms of more stringent lockdowns, we're available nights, weekends, if necessary. Give us a call. 866-DADS-LAW. Happy to have a chat and a conversation and talk to you about strategy and get you some more information, things that we can't specifically do here in this virtual town hall during the 60 minutes that we're with you. But we're going to give you some high-level stuff today, and that's what we're going to intend to do. But remember, submit your questions in the Q&A section. They're coming in now. We want to address that in the second half of our town hall, where we'll answer those questions as best as we can. So let's go to Kim Gray. Kim, as we talk about experts in divorce, particularly, I mean, obviously we can use experts in all facets of family law, depending upon the issues. One that really affects a lot of people is the use of appraisers for whether it be real property, which is a home, or a condo, or something in which you have an ownership value in, or personal property, jewelry, art, anything of intrinsic value. Gosh, it could be nowadays you see people are collecting coins, whether it be gold bullion. We want to value it. The question is, let's start simply. Kim, what is a property appraiser, in divorce, and why should guys be interested in that?
Sure. Well, property appraiser is a hired expert, and that expert investigates the marital property to help give a value. They give a third-party, unbiased estimate of your home's true value. And like you said, it could be anything that's marital property. It could be antique cars, other antiques, high-value furnishings, jewelry, art, anything that you and your spouse own that we need to know a clear value for. And the property appraiser would come in, they would evaluate and determine the fair market value for that property. So,
the natural question guys are probably thinking is, all right, they're giving me a fair market value, but why can't I just get up there? I mean, the seven of us that are sitting here right now, we may have a house and we all have an idea of what we think it's worth, right? Some of us are going to go high, some of us are going to go low, and some of us will hit it spot on. Why would I even bother? Why do I need a property appraiser? Why can't I just get on the stand, Kim, and tell you my house is worth $150,000?
Well, first of all, just like you said, I mean, some might be high and some might be low. And what you need to get is a true value. Most states use an equitable division to determine how property is to be divided. And in order to do this properly, we have to know exactly what it's worth. And we've got to be able to tell the judge that. And often the marital home is the largest asset that we are going to be dividing. And without that accurate appraisal, you could severely undercut yourself in a fair distribution. Mm-hmm. So what you need to do is you've got to be able to tell the judge an unbiased opinion on what it's worth. You can't, a lot of people come in and say, well, I can just go on Zillow and Zillow is telling me what it's worth.
Yeah, I was just doing that right now just to see, right?
Yeah, Zillow isn't accurate. Sometimes it is, but do you really want to risk your largest asset on a website that may or may not be accurate? A lot of people come in and they want to use the tax assessment. That is always off. That's way low. You severely undercut yourself with that. And then sometimes you say, well, I bought the house 4 years ago for X amount, and my neighbor's house sold for Y amount, so mine's probably worth that much. And it's just not accurate. You just want to make sure that you get the right value. When you're selling the house, when you're dividing the house, you could either keep it, maybe your wife's going to keep it, or maybe you guys are going to sell it. And say your wife decides that she wants to keep the house and you don't have an accurate value, you're going to have to buy her out of that, or she's going to have to buy you out. And you want to make sure you're getting the right amount.
Yeah, I mean, I think you have to be cautious about the apps that are out there, and whether it's on the web, like Realtor.com, that give you estimated values, because it ignores it sometimes. It ignores a hot real estate market. I mean, if I go online and look at my property now, it's going to undervalue it, because the market is so hot in certain spots that you'll see. And I've got a realtor friend who talks about every home she's listing is going for 30, 40, 50,000 over ask, and far more than what these, common apps are selling for. So I think you have to be careful, because the premise is this, and I know it's annoying for many people, and that is, we have to divide property. We have to value everything so that the judge has somewhere to start. And I think that's the danger, is getting in a he said, she said. The judge could easily say, look, I don't have any confidence in any of the values given to me. And so either they split the baby, or they value it at zero, or they undervalue it. And especially with a real estate appraiser, the cost benefit, it's so inexpensive in the grand scheme of things, if you're thinking about either wanting to get value out or keeping the house. So I agree. So property appraiser comes out, typically, some people have never experienced it. What do? Do they come take pictures? They use comps? They look at the market conditions, the market in terms of its selling and buying? Is that what they're doing?
All of those things. They'll definitely come out to your house. They'll take pictures, they'll take measurements, they'll count the bedrooms and the bathrooms, they'll look at any improvements you've made, assess the house for any needed repairs, and then they do a comparative market analysis to determine the fair market value. All real estate appraisers use the same form. They use the residential appraisal report, so that it is uniform across the board. There are several different approaches to calculation. Most of them will use the sales comparison approach, which is the one that we just talked about, that compares to other houses that have sold. Occasionally, they might use the cost to replace approach, which is basically based on the premise that someone would buy your house versus what someone would buy your house for versus what they could get if they did a new build. It's not used as much. And then the other one would be the capitalization of income approach, which is used when you have rental property. So often people have their house, but then they also have like a rental property that they're using and they're collecting rent from. And we also need to know the value of that, because there's also some added income there.
Yeah. I mean, I think the point in you're making here is, we don't want to miss out on an item of value and miss largely on what it's worth if she's keeping it, or you're giving it to her, and you want to, if we want to divide everything 50-50, if that's kind of the way we're going, we want to make sure we get it all. I mean, it's not necessarily we want to value the knives and the forks. I mean, those have value too, sofas and tables and televisions, but I think it's important to ensure that you do it. Now, as we close out this part, not automatically hiring an appraiser. It's strategic. You want to think about, I think we were talking off camera yesterday about this, and that is, I had an opposing party value a home at a far, far, far higher value than we ever thought an appraiser would come back. And so the point is, okay, skip the appraiser, accept her value, give her the house. Much better, right?
Absolutely. I've had that happen too. And it's like, okay, you take the house, buy me out and give me half of what you believe the equity is. And she's way off. That's a win for us.
Yeah, agreed. Jerrad, let's transition. I know we want to keep on track so we can address questions in the second half. We have them coming in now. Don't forget, submit them in the Q&A section. We're going to address those questions here 20, 25 minutes or so from now. So get those going and we'll get those. So Jerrad, big words, forensic accountant. Guys hear this a lot. Lawyers know what it is. Lawyers tend to love it. What is a forensic accountant? Kind of what would they do for you in a divorce, and why is it important?
Forensic accountant is going to dig deep in the financial records to determine what's really going on in regards to the party's finances, such as income, expenses, possibly assets and debts. They're going to review anything and everything as far as it relates to financials. So they're going to review tax returns, bank statements, retirement account statements, debt statements. They're particularly helpful when we've got various business interests going on, various properties. And if our client hasn't really participated in the party's financial affairs, they're very helpful for us to get a better understanding of what's really going on in this marital estate.
Yeah, I think what's interesting is when someone thinks of expert, they tend to think, well, I got to have a lot of stuff. I got to have a lot of money. and I don't have a lot of money. I don't have a lot of things, but that's not necessarily true. I think, it depends. For example, we were talking again today off camera, and one of the great things about Cordell Cordell is when we're so diverse and spread out around the country, we often have our attorneys email each other. We have 300 lawyers, and we love to give advice to each other and give strategic direction. And one that was going around was, hey, spouse is a hairdresser, cash business. I'm trying to trace and see how much they make. I've talked about this in a podcast, this latest fad of online selling beauty products or teeth whitening or jewelry online. It's really hard in a cash business or an unorganized business to be able to trace that. But guys who have spouses that are involved in cash enterprises, you can use an accountant to trace it, right?
Oh, absolutely. And I find that's when forensic accountants are most helpful. To determine and quantify personal expenses accounted for as business expenses. And that's going to impact the value of the business, but also the party's incomes. For example, I recently had a case where opposing party was claiming a $45,000 a year salary, and she needed spousal support. Our client made significantly more. I need spousal support. So what we did, we had a forensic accountant go through everything, tax returns, bank statements particularly, and they determined that almost everything being charged with the business was a personal expense. So we were able to add back in approximately $60,000 in income as personal income and reduce and minimize that exposure for spousal support. So it's very helpful when it comes to determining and getting an accurate depiction of the party's incomes.
Yeah, I'm a big fan of experts. And I think what, as guys are listening and watching today, they'll see is a lot of these experts they interact with each other, where you can use one, and we're going to talk about vocationals later, an accountant and a vocational would work hand in hand. Why it's important is our job is to minimize exposure financially for guys. Do you want to pay the least that you have to, because you want to keep the most? And so in order to do that, it can't just be a guy getting up there saying, well, here's what I make, or here's what she makes. I know she makes it. I see the cash. Judges want perhaps a third party neutral, someone who, it's a hired person by you, but they want someone who has a higher knowledge, a better understanding, and can show how they arrived at the calculation, right?
Correct. It's important to have an expert on your side when it comes to trying to impute an income to somebody, because your client up there's just stating that this is what they earn isn't going to cut it. You need to prove it. You need to have an unbiased third party to prove here's what their income really is and here's why. Otherwise, they're just going to take probably the other side's word for it, because they're going to have more information as far as what their income is and what their cash flow is.
Yeah. And I think more importantly now, with the tax changes that were put into effect, which eliminated the deductibility of maintenance payments, now more than ever, if you live in a state in which there's no calculator, there's no formula, you want an accountant to say, what does this real effect to you? And what does a guy have left? Because likely around the country, one of the factors when you think about spousal support is the ability of the payor to meet their reasonable needs and expenses before they make that payment. So you got to know what the guy has available. Can he live reasonably before court enters it? Judges want to hear that. Now, let me transition real quickly on this, Jerrad. It also comes in where you can hire an expert to help you in the analysis of your case and perhaps to look at the other side, right?
Absolutely. Experts are vital in the preparation of your case, especially when the other side has an expert. In my opinion, if the other side has an expert, you have to have an expert, because they're going to assist in discovery. They're going to inform us as to what we need to request and what questions we need to ask so we can get the right answers and the right information we need to put the best case forward. Plus, they're going to assist us in cross-examining the other party's experts. To be honest, without that information from our own expert, it's going to be hard for us as attorneys to really know what to ask the other expert. We might have a pretty good idea, but without that expert telling us exactly what we need to ask, it's going to be difficult for us to really get to what we need to get to. If we don't have that, then the court's going to accept the other party's expert. And we need that expert, our own expert, to testify at trial and during depositions to help our case and maybe help facilitate settlement in these matters.
Yeah, I think the point is you should have a conversation with your attorney. If they haven't made suggestions to you of experts, and I think that's a red flag. You don't have to do it, but you should have a conversation about it and make sure that you've considered it and a cost benefit. Is this going to be better for me? So Tomekia, let's kind of transition to you. We talk about custody. We've talked about property, we've talked about things and money. Now let's talk about custody evaluators. You say don't roll the dice. What does that mean?
Well, so great question. To be honest, a lot of times parties walk into court regarding their child in custody, and they automatically assume that when they walk into court, that the judge will always be favorable based on the evidence that's presented. Well, the reality is it doesn't always work that way. There are judges who I dub as mom judges. There are judges who have become more favorable to one party over the other because of prior court proceedings. And there are judges in which there are situations where they take and consider past behaviors and actions more harshly than they would if it was a child custody evaluator who looked at the bigger picture. And so when I say don't roll the dice, I mean, make sure your attorney knows whether or not it's more beneficial for you to take your action and your request for custody before the judge versus allowing a child custody evaluator who has more of a bird's eye view to make that determination.
Yeah, I think it's a conversation I have routinely with clients, and that is, look, you have incentives to try to negotiate because ultimately you're leaving everything you've earned, everything you've worked for, and your kids in the hands of someone you don't know. And that is a judge. And that's a difficult thing because you have no idea what their beliefs are. You have no idea how they feel towards custody sharing. They don't know whether they're pro dad or pro mom. Your attorney can likely say based on history, what they do. And I think that's important because, get an evaluator, someone who can present evidence for you, right? So there are qualifications you want to look for, qualifications that an evaluator should have, that guys should be considering, right?
Absolutely. So just to be clear, in terms of the qualification, so we attorneys, the judges are obviously attorneys before they became judges. And so we don't have the same criteria and background that's required for a child custody evaluator. A child custody evaluator needs to ensure that they have a degree in human services, number one. And number two, they need to have a license to practice either as a social worker or as a counselor or a therapist or a psychologist or someone of that magnitude that has that background. Obviously, we lawyers, we go to law school, but we're not required to have those particular backgrounds in terms of the judge making those decisions.
So and I think caution guys are thinking it's easy to mix guardian ad litem, or child representative, whatever they may be called in your state, with an evaluator and a psychologist, because, and I always caution because I sound harsh when I say this, and you mentioned it, lawyers are not trained in custody matters. We're not trained to understand and evaluate, where's the appropriate place to put a child. We're trained in the law, where psychologists are, but a guardian ad litem is an attorney, and they have 12 hours of training on how to mediate. I might as well hire a plumber, to make that decision. So I'd rather hire an evaluator to look at me, look at my kids, talk about the interaction, and tell a judge based psychologically, let's use science to try to influence the judge. And don't you agree?
Absolutely, I do, 100%. And just to be clear, in terms of the situation with the child custody evaluator, you need to make sure that you are aware of every action that they are allowed to take. They have more time to commit to each particular person and parent and child versus a judge who only has a limited amount of time in a courtroom to hear the evidence and testimony that their attorney presents to that judge.
Yeah. So the one thing that many lawyers overlook is preparation. So at some point, you, the client, are going to meet with this custody evaluator alone and answer questions and talk through things. And then you'll see some interaction with your kids, and then they're making judgments and analyzing. So preparation is key, correct?
Absolutely, it is, for sure. And obviously, with the child custody evaluator, they have the capability to meet face to face. They can interview the parents. They can interview the children with the parents. They can speak to references who's provided. There's a laundry list of actions that a child custody evaluator can do theoretically in terms of allowing a court to know more detailed background in regards to each particular parent and their history and where things are moving forward.
And so we talk about guardians. The evaluator is going to make a recommendation, either in writing and perhaps on the stand. and they'll present that to the judge. And if there's a guardian, you can have both. I mean, right? You could have a guardian on the case and your own hired evaluator, and they could have reached different conclusions, correct?
Absolutely, because just to clarify, so a guardian obviously have the ability to be able to speak with the court in regards to that particular child and the actions that they've experienced. However, with a child custody evaluator, they have the ability to be able to spend an insurmountable amount of time between both parents with both the children or child and the parents. They do background researches on the parents. They look at medical records, text messages between parents, school records. And so they can engage more, but obviously it's beneficial to have both if you have the ability to hire both.
Yeah. And as we transition to the next topic and just close it out, my point is I'm a big believer, again, of custody evaluators, and you have to analyze your situation. One, make sure the other side isn't going to use one. I never want to walk into a case in a trial where they've got the expert, we have none. I mean, I think that's a recipe for disaster. Unless you can effectively and efficiently cross-examine and prove to the judge that their findings are, inappropriate, incorrect, not founded in fact or law or whatever it may be. So I think that's key. So consider it. Have that conversation with your attorney about whether a custody evaluator is appropriate for you and whether you can benefit from it. So Jason, let me turn to you. I want to talk about retirement plans and how can we use an expert if a guy has a retirement plan?
Well, so there's essentially two types of employee-sponsored retirement plans that we're going to be looking at. The first is probably the more traditional, what you think of your 401k. That's called a defined contribution plan. You don't need an expert to value a defined contribution plan because you can pull up and get a statement, and we know what it's worth. You can get statements from the date of marriage and the date of separation so that you can value the marital portion. So we don't really need an expert for that. However, pensions, defined benefit plans, is what they're technically referred to, are moving targets. They need an expert to value them. These types of plans are where your employer invests the money for you. So you just can't pull up a statement and say, here's what it's worth on today's date. Here's what it's worth the day we got married. Here's what it's going to be worth the day that we're divorced. You need an expert to come in and say, here's the value of it now. Here's the value of what your monthly payment is likely to be whenever you retire, which is what this all is going to be based off of.
Mm-hmm. Yeah, pensions are tricky. I mean, not only that, you've got surviving spouse benefits. Courts want information to know, especially if you've got maintenance calculations coming in the door, or if payments are going to be made very, very shortly. It's going to impact the judge's analysis when it comes to that. So what type of expert would do a pension valuation?
So because we're looking at the future, and when you think of the nature of a pension, it's going to be, you're going to get X amount of dollars from the day you retire until the day you die. So that's going to be an actuarial calculation, projecting how long you're going to live after you retire. So that's going to be done by an actuary who has specific licenses to be able to evaluate this and then give you an expert opinion on whatever that, either the lump sum value or the monthly payout amount is going to be.
Yeah. I mean, it gets very complicated. I was representing a client who was a government employee, and they had 3 different pensions. And it was very complicated about when the earliest retirement age was, how much was actually going to be paid, what would be paid if in terms of a divorce. And then I had one here in Missouri where teacher pensions are not divisible. And we had a brand new judge who needed to be educated on the fact that you cannot divide teacher retirement. So I brought an expert to say, yeah, you can't divide it. I'm sorry. And I think that's huge. So the question is when should a client, he's thinking, okay, I've got a pension. Jason, sounds great. I need to hire an expert. When should I do it? And how much is it going to cost me?
Sure. So just to highlight kind of what you said, I was just reading a case out of Florida which compared pensions to a snowflake because everyone is different, everyone is complicated, there's nuances to each and every one. So to tie that into your question, because of that, it's good to have this information as early as possible in the case because with the knowledge and the information about the nuances of your plan provides leverage throughout the case. So whether it be settlement conferences at the beginning of the case, or obviously as you prepare and go to trial, knowledge is leverage in these types of situations because as the pension holder, you hold the information, and very rarely is the other side going to proactively get a valuation of this. So the way you negotiate and the way you approach the settlement conferences, you can do so with the power of knowledge and knowing what your pension means and what leg up that might give you, as opposed to when you consider what you might want to give up in the divorce or what you might be willing to give up. But to answer your question about costs, these are relatively inexpensive, which is another reason why they're worth it. You can, for an initial evaluation, you can usually have it done for anywhere between $500 to $750. And that information can be incredibly powerful, like I said. So it is worth it. It's something that I suggest to all of my clients that have pensions, because no one knows what to do with them. And if you know what your pension holds, you're going to have more information and more power than opposing counsel, and even more knowledge than the court in these. So it really does provide a solid strategy and lets you operate from a good position of leverage.
Yeah, I think you're right. I had a client who didn't want to give up his pension under any circumstance. And I said, look, it is marital. The court will divide it. The only way to get around this, as you suggest, let's go value it. Let's figure out what it's worth and let's negotiate it away. Let's give them something else in exchange for you keeping the pension. Is that the best use? Probably not. We have to, you have to put a dollar value to it and understand the tax ramifications, which, before we go into the next topic, is actually a good point, Jason, is that, here at Cordell, we have a quadro department where they just simply deal with that issue, right?
Yeah, so we do have a department that will be able to tell you a lot about your pensions. Now, we aren't going to be able to give you present valuations of the pension. We're not able to do that. We don't have the qualifications to do that. But we do know about the pensions. We can tell you a lot of the detail that an expert's going to be able to provide to you, and that's all part of your representation package that you get with the firm.
And I think it's important for guys to ask their attorneys, hey, do you have someone on staff? Do you have a department solely dedicated to retirement accounts, quadros, federal pensions, whatever that may be? So let's go to Jill Massey. Let's talk about businesses. It affects a small number of guys out there. They may have an auto repair shop. They may have, sole proprietorship, something that they don't think of as a business valuation. They hear that. They're like, well, I got to value your business. What does that really mean? What is a business valuation?
Sure, Scott. So I will say I'm excited to have this topic. I have a finance degree and a business management degree. So this is my sweet spot. And Scott, I know you are exactly the same. I know you love this kind of stuff. We get to flex our business-minded muscle when business valuations come up, and they often do. A business valuation is an assessment of a business to determine the business's economic value, or fair market value would be another way to say that. The name says it all. We are valuing the business. It's basically, Kim was talking about appraisals. It's an appraisal of the business. So it's a niche type of appraisal. Yeah.
I think that the point is again, we've said, we'll go all the way back to real property. Our client can get on the stand. I know what it's worth. It's worth nothing. It's just all me. But the judge needs to have something more than that. And that's why it's important and imperative. And it's risky, because if you as a client tell you, Jill, hey, I'm not going to hire an expert. I'm just going to get on the stand and tell the judge what it's worth. And the judge can assign any value they want based upon the facts and evidence provided. And that could be a value that is far more than what it's truly worth, right?
Absolutely. And I've had that come up in a case where we've actually had competing experts, where the other side's experts wanted to value my client's business at something like $2 million, when our expert had it closer to zero because of certain things that had happened in the recent past. So imagine us walking into that courtroom without an expert, and the other side has an expert that says it's worth $2 million. I mean, it's game over at that point. You don't stand a chance.
Right. I've got a case right now, which is so interesting. Client owns a restaurant. Imagine that during COVID-19. And the other side is saying, oh, it's worth X number of dollars, when in reality, that place had been shut down for 9 months. It's worth nothing. And now, will a judge probably use reason to conclude that's worth nothing? Probably, but I think you're safest to have an expert to come in and say, yeah, it's devastated because of COVID. You have no revenue over a 9-month period. No one's going to buy it, because that's a factor in terms of valuation. Is there a market for this? Is there kind of some precedent in terms of its value? Have you received an offer to buy it? So I think it's key for you to really have a consideration, understanding of, you got to have someone, you work very, very hard to build this business yourself. So protect it. It's like hiring an accountant. I would say most business people will hire an accountant to do their taxes. Well, why don't you do it yourself to save the money? Well, it's too complicated. Exactly. That's the point. The valuation is also equally complicated. There's some goodwill involved that has no value. So guys are saying, okay, fine, I'll hire an expert, Jill. What are they going to want to look at?
You mean in the terms of what the expert is going to look at, or what type of expert?
What will the expert look at for the client? What do they want to see from them on their business?
Yeah, so the really short answer, which I will elaborate upon, is the books. They want to see the books. They're going to look at the tax returns. They're going to look at the data that goes into the tax returns, if they have any sense, because tax returns are one of the most largely manipulated documents that we see both in personal and in business settings. Mm-hmm. They're going to look at the industry the business is in. They're going to look at the business itself, what type of business, what is going on around. Just like you said, COVID has thrown us all for a loop, and it's impacted businesses largely. So the business valuator, the expert that you hire, is going to have very specialized training to know exactly where to look for the information that they need to put an appropriate value on, whether it be the business that you operate, or whether it be a business that your spouse operates, or whether you all are doing it together. It could even be a family business. Can you imagine having a business passed down over the years from your family, and your wife has helped you out in it, so now she's making a claim to it? I mean, there's a lot on the line, and the business valuator is going to be the one that knows exactly where to go to look for the information, whether it be internally, lots of internal factors, the books, but also externally, the environment, the industry, things like that.
Yeah, and it gets so complicated. Particularly, I had a surgeon, and he had a fractional ownership in a surgery center, and the other side was valuing the entire entity rather than his 6.78% fractional ownership. I mean, you're going to get an expert to come in and say, yeah, okay, it's worth 100,000, but your client only owns 6% of that 100,000. So you've got to be really careful. It gets very complicated. And again, you don't want a he said, she said situation. So we talked earlier about this crossover between experts, where you may have multiple experts doing one thing. We've already talked about forensic accountants. So who does business valuations? Is that an instance where maybe we have an accountant who can do an income analysis, a cash flow analysis, finding money, finding hidden money, and also do a business valuation?
Yeah, so I would say probably 90% of the time, if not maybe even more, when I have a business valuator come in, I also have that same business valuator who is an accountant, and they're an accountant who specializes in business valuation. To be clear, you don't want just a CPA, you want a specialized business valuator or accountant. I will have them also do an income analysis, because they go hand in hand. And even though an income analysis is something that I'm capable of doing, the accountant usually does it at a lower hourly rate. Yeah, and that's their niche. So why not let them do it?
Yeah, I agree. I mean, I think it's huge to make sure. I mean, I'll tell a client, look, if you've got a business, we've got it. This is just one of those where it's no questions asked. You've got to spend the money, pull it out of the business, whatever it may be. It's going to take cash out. So, I couldn't, and I think you'll agree, I couldn't tell them what their business is worth. I mean, I can look at a cash flow. I can look at an income statement. I can look at the balance sheet. We can kind of make some assumptions, but there's some other factors that the IRS talks about in terms of valuation. There's some, minority interest discounts that happen when you talk about business valuations. All that comes into play, right?
All of it. And you mentioned discounts. So one of the things that a business evaluator is going to do, and also in the income assessment, is they're going to be like discounting cash flows. And even just saying that, it's like, what in the world does that mean? Well, you don't have to worry about what it means, and your attorney isn't classically trained to know what that means unless they have a heavy business background, but that's what the business evaluator does. They're going to know exactly where to go and to look at that type of thing to get you an accurate value on whether it be, again, your business, her business, joint business, whatever it is.
So you mentioned income analysis. It's a great transition. Dorothy, let's talk real quickly in transition before we get to the question and answer session. Remember, submit your questions. We've got a number of them in the Q&A section. Do that now. We're going to get to that very, very shortly here. So income analysis, one of my favorite, you and I tried a case together, Dorothy, about vocational experts when it involves spousal support. So guys may have heard this vocational evaluation or a vocational rehabilitationist. What is that?
A vocational rehabilitationist is someone who comes in and gives the court an unbiased opinion about what someone can truly earn. Especially in today's economic circumstances, so many people are either out of work because they are forced out due to the market situation, but also so many people are out of work because they choose to be. And what we actually put on our books, as Jerrad and Jill have talked about today, may not really be reflective of the potential and capacity we have to earn as a spouse. No one wants to pay more support in the form of child or spousal support, alimony or maintenance, however you want to phrase that. No one wants to pay more than they should. And in order for the court to have an understanding of both parties' income, as you said earlier, we need to understand what's your net income, what's the other party's net income. We need to have a true and accurate picture. And that's Jerrad referenced, it's an imputed income. Imputed income means we hold someone to the highest standard that they're capable of earning. And we need expert testimony to do that. As much as I would like to tell someone what they're capable of earning, and I've tried, we really need an expert to come in and do that.
Yeah, I mean, I think the best thing is the example of the case you and I tried. I mean, it's one thing, for example, if you're on a modification of maintenance or even an establishment of maintenance, where you have an unemployed spouse, or maybe what we would refer to as an underemployed spouse. I mean, it's one thing to say that they're doing nothing. But then judges can't speculate. They have to have evidence. They have to have something in which to establish an income. I mean, we know what the minimum wage is, and we certainly don't want minimum wage imputed to a spouse if they have higher work history, higher credentials. So in the case we tried, an unemployed nurse, someone who had been out of the workforce for a while, right? And we used a vocational expert to do what?
We told the court what she should be earning, and the court bought that. And I will tell you, I had a recent case, Scott, similar, where she was also a nurse. She hadn't worked for years. And the vocational expert I hired, who generally it's a master's level person with a social service type background, and then they get an accreditation to become a career counselor, sort of. But a lot of them also have psychological backgrounds. And in that case, the evaluator found that not only was this lady capable of going back into the workforce at 51 years old, she was also malingering and making excuses for why she couldn't. And that's part of what the assessment is. If someone's coming in and saying, well, I can't do these things, I'm not capable, the evaluator doesn't just look at history of their employment. They look at their psychological, they look at their medications, they look at their physical limitations. They do a very full analysis on this person's capacity to work. And I want to say you can also use it, that's a defensive way. You can also use it offensively, where if you feel like something has majorly changed, like your restaurant owner, and now what your prior books say are not accurate about what you can earn, you can use it to defend spousal support claims as well. Yeah. Well, I might have been earning that before, but I opened a restaurant when I was 20 years old. I don't even have a college degree. I certainly can't earn $300,000 a year anymore. Yeah. And that's a really important way to think about it. And again, discuss with your attorney and find out if you can bring this person in to do an evaluation on one side or the other.
Yeah, it's similar to the recession, in the early 2000s, 2006 through 2008. Now we have COVID, where we have, enormous millions of people laid off. And you may be a guy who's like, yeah, I was laid off and now I can only get a job at half of what I was making. Judges, you may take the risk and have a judge understand, which probably most will, but the other side's going to argue you're capable of making the money that you made. You may be a 55-year-old guy. I know someone who was laid off making, 6 figures, no chance, not going to find that same job at that age. And they, employers will never say it, but we know the reality of it. And the vocational will do an analysis in the market. They do this blind, they call and say, I've got a client, 55, this experience, this education, is there a job position that you would interview them for? And they may say no. And so they can say, said, yeah, I called 10 employers and 10 said no. And that's the kind of evidence that you're going to want, right?
Absolutely. The job market analysis is by far the most important part. When I receive a report, which is generally what you receive at the end of the evaluation, after the person has gotten all the information they need from collateral sources, as well as the person in person for an interview, they generate this report. And the first thing I do is move to that job summaries, because it is so key that they have not only looked in the correct geographic area, the correct background. I have personally sent back multiple reports and said to the evaluator, I view this as a draft report because you have not done a thorough enough job search for my client's circumstances. I had that recently with a surgeon on the other side. She was only earning $140,000 as a surgeon because she was military. And I said, there have to be better options here that you have not considered. And lo and behold, I got something back better when they did a more thorough review.
Well, okay, it's time for our lightning round to get to the questions that have been asked. You can still do that right now by going to the Q&A section. We're going to fire through those in the last 15 minutes of our town hall. Remember, we can't give you legal advice. We're going to try to give you just some direction here from our panel and put you the right way. But remember, if you need specific legal advice, set up a consult with us at 866-DADS-LAW. Find us on the web at CordellCordell.com. So let's go right now. And Michael from Maryland, obviously, we don't have anyone licensed here in Maryland, but let me throw this to you, Jill. Michael in Maryland, does child support continue past age 18 when it wasn't indicated nor stated in the absolute divorce in May of 2008? So, Michael, obviously we're not licensed, our panel isn't licensed here, but Jill, give a kind of an overview. If it's silent in a decree, for example, in Georgia or Kentucky, what would typically happen?
So generally speaking, the orders will most of the time, at least to get my experience, Kentucky and Georgia, the order will state when the child support obligation terminates. In the event that it doesn't, there's going to be a statute that is the default, the governing rule there. So a great place to look would be the statute that will say it terminates at 18 or perhaps when they graduate high school. There's a couple different variants that we see across the country. So go to the statute, and if you can't figure out where to look in this for the statute, we do have attorneys that are in Maryland, I believe, who would be happy to sit down with you and look at that.
Yeah, it is. It's statute will control, or the code will control, even though it's absent. Typically, when it comes to support across the states, you can't contract the rights of the child to receive the support away, even unless it's something even outside of the decree. The court would never have approved it. So the first way to look for is in the statutes, as Jill said. Obviously, I have a Supreme Court case where parties moved, and we took that up to the Supreme Court, and which state actually controlled the age of emancipation. Missouri was 21. I think it was Oklahoma was 18. And there was a question like who controlled, and it's usually the decretal state where the divorce happened. So Michael, take a look. Obviously you can reach out to our Baltimore or other Maryland attorneys and you can get an answer for you. So Jason Lasser, question out of from North Carolina, since you obviously overlooked or oversee some of those offices. Andrew wants to know, and this is a common question, or is it Jerrad? Are you doing it now?
I oversee North Carolina.
All right. Well, then, I'll give it to you, Jerrad. How about that? And everybody can weigh in, because this is a really interesting question. I have some thoughts on it too. Is it important for a Cordell and Cordell attorney to have an everyday presence in the court in which the client's going to hire you? It could be a couple hours away from our office, right? This question happens. I've been asked that a lot here in Missouri, where we have, in the boot heel of Missouri, or, an hour or two away. The question really from Andrew is that really someone Andrew should be looking for? Is someone in that town only, or is a Cordell attorney going to be as equally effective?
It's a great question, and I come across it quite a bit as well. And I do think a Cordell attorney is going to be equally as effective. The great thing about our North Carolina offices are we're spread out throughout the state. So we've got 4 now, really 5 offices in North Carolina, all spread out. So we've got somebody covering all the areas, and they're familiar with those counties. For example, we just had a consult in Raleigh, and we changed that over to Asheville. So we've got Asheville covered now. We've got Charlotte area covered, Wilmington area covered, and Greensboro. So it's North Carolina law. I'm not licensed in North Carolina, but North Carolina law, it applies to every county, every jurisdiction. Every judge does have their particular things as far as procedure goes, but a licensed attorney in North Carolina is going to be able to handle the case, and we're going to have somebody that's going to be able to handle the case in that jurisdiction or in that county, just based on experience due to each office covering various counties.
Yeah,
on a regular
and I
basis.
think it's important to note early on, it's our 30th year that we've been doing this. 28, 27, 26 years ago, maybe my answer would have been a little bit different. But the fact that we're the largest that I know of domestic relations firm in the country, our reputation precedes us. Courts around everywhere know Cordell and Cordell, and they hear it. They know kind of what we do. So I don't think you need the Main Street presence that you used to have when we weren't 300 plus lawyers. And I think that carries a lot of weight. I'll go down into the smallest of communities in Missouri, and they know who we are. And then the second part of that question was really travel costs. And I think, having someone from Wilmington travel an hour or two to the local court, and I'll answer real quickly. The best thing, we can look at COVID as the negative, but we always try to find the positive. And that is, I think COVID has transformed and transitioned the cost for clients dramatically. Now we're appearing just like this via Zoom. Court hearings are having via Zoom, temporary hearings, status conferences. So you don't have the travel costs that you otherwise would have had pre-COVID. Yeah, it would have been an issue. It could have been cost prohibitive when you have 10 appearances in 2 months. But now what you're likely to have is perhaps maybe one. If they're going to hear cases in person in a final trial, yeah, I think it's worth it. But everything else will be handled via Zoom, by telephone, all remotely. So I think that's the best thing about COVID. Dorothy, go ahead.
Sure. Before we move on, I think there can actually be an advantage to having a Cordell attorney come in. And as someone who, like I said, I've practiced in 5 states. And so I've been the new kid on the block many times. And sometimes coming in with a fresh perspective that isn't business as usual, accepting the answer that, well, this is what the judge always does, or this is how we just do it here. Sometimes that's not what's best for representation of clients. And sometimes being an outsider gives you the opportunity to think outside the box, be more creative with your representation, which I think is something we pride ourselves on here. And so think of it that way. There could actually be an advantage. I definitely don't think there's any downside to it, as Scott and Jerrad have both pointed out.
Yeah, agreed. All right, let's go to the next question. Let me pull it up real quickly here. Another Maryland, which is Maryland's popular today. Tomekia, we're going to go to you.
All right.
This one is anonymous, but they have shared custody in Maryland, one overnight during the week and every other weekend. My ex-wife is extremely uncooperative. The person's planning to travel overseas on a trip that could overlap the one-night weekday. What would be a good legal reason I could use for my travel without getting myself in trouble? I'm willing to negotiate with her to make up that one day before I leave or after I return, but she's being difficult to communicate or negotiate. Really, what does this person do?
All right, so just to clarify, in terms of a good reason for your travel, I guess the question is whether or not there would be any issues or concerns with you traveling and missing that one day. I mean, obviously the courts know that parents travel and sometimes the possession schedule isn't always followed. And so in a situation where you have concerns that you may get in trouble, it may be wise to consider having a mediator, a third-party person, sit down with you and your wife in an attempt to try, or your significant other, to try to resolve that issue before you leave outside of the area.
Yeah, I agree. And I think, judges, they want the parties to negotiate. They understand that things happen. They understand that schedules change. And keep in mind that your decree and your schedule is really just a framework. And really it says that you both should agree, and absent agreement, it dictates. But, if you're going to go over, judges are going to want to see someone just say, oh, sorry, you lost it. You can't make it up. They're going to, just paper trail, communicate saying, hey, here's 10 different days for me to make that up. Please let me know what works for you. And then you can just show the uncooperative and unreasonable behavior of your spouse.
Great.
All right. Let's go to Michael has a follow-up question from Maryland. And I'm going to go to Jason Lasser, since Jason was trying it. So Michael wants to know, when a former spouse has remarried, is any additional spousal payments allotted from SSI or other pensions permanent earnings? Since this is her third marriage, is she allowed to garner payment incentives from each marriage, including other financial benefits? So I think what Michael may be asking is subsequent earnings, subsequent retirement, SSI, disability, is that going to count towards perhaps financial obligations, financial analysis, spousal support, child support? I mean, obviously she can get it, but will that be counted against her income? I'm thinking what Michael's asking.
Yeah, sure. So I'm licensed only in Pennsylvania. And so I can tell you under Pennsylvania, first and foremost, the fact that she is remarried would terminate any further spousal support obligations. Now, I'm guessing if this is her second or third marriage, you might have already looked into that and know that that's not applicable under your law. So if your obligation is modifiable, which again in Pennsylvania, we're not necessarily modifiable once we have an agreed upon alimony award or maintenance award, but if it is modifiable, all of those things should absolutely be considered, whether it be any stream of income, whether it's Social Security or pension income or just a regular job. All of those things should be considered in an analysis. And if her situation has changed significantly since when the original maintenance order was entered, it would definitely be worth looking into, even if you aren't in a modifiable state, just because the circumstances are so drastic as when it was originally set.
Yep, agreed. All right, let's go to, who do I have left here? Let me make sure I'm getting everybody. Let's go Kim. I'm just going to throw it out there. Kim, roll the dice. DL. Actually, last town hall, I think, had some questions about his case. And here's, we have to be careful about making sure we don't dispense legal advice on this one, but just give some direction. So last time I asked about how to depose a doctor. He was my child's pediatrician. He wrote a declaration based upon a 20-minute meeting with me that my ex is using in our divorce. DL happens to be a lawyer. When I tried to depose the doctor via subpoena, my ex's attorney changed position and argued they were no longer relying on the doctor to say I'm unstable, but they keep citing to the declaration that's been filed in the court. DL did not withdraw the subpoena, and they moved to quash it and for discovery sanctions. My opposition, or DL's opposition, is due in 2 weeks. He basically wants to know what's the best way to approach this in terms of trying to get this deposition when they continue to rely on a declaration that's filed with the court. So it's a complicated, really it's a discovery question. What is DL to do? And I mean, my first analysis is proceed and have a hearing on the motion to quash and argue that if they're relying on something, obviously it's, the rules of discovery are that anything is available if it's reasonably calculated to the discovery admissible evidence. If they're relying on something that this doctor said, then certainly you can do a depo.
Right. I would agree with that. I definitely think he needs to move forward with the motion to quash, though, because if they're saying they're not relying on it, but they constantly are relying on it, then we need to address that first and foremost.
Yeah, and I think discovery, you have nothing to lose here. The point is that if in fact, maybe what I would do, DL, is think about sending correspondence to the attorney that said, are you going to withdraw the declaration and not rely upon it? And if they say no, then I think that's enough grounds that you're probably on good ground when you oppose the motion to quash and say, look, I have no reason to believe that they're not going to rely on it. And then DL also has some requests for admissions that haven't been answered. I'd file my motion to compel and for sanctions and have it all heard at the same time. So, all right, let's go to the next question. Kim, I'm just going to stay with you because it's Missouri. John asks, I own a business and I'm going through my divorce with my ex. I'm supposed to be turning into my personal and business expenses to my attorney. I run my business from my home, so there's a lot of crossover of what I pay personally and what my business pays for. I want to be transparent. Any insight on on how I should figure things out, what to separate from business and personal?
Yeah, it's super important to make sure you're separating the business from personal for lots of different reasons. And I think that goes directly to what we were talking about earlier with experts. And I think an accountant, it would be really beneficial in this situation to kind of go through those accounts, separate out the business so we know exactly what is business, what's personal, and that way we can determine what the business is worth, how much income you actually have, and not have that all commingled, which could really skew your numbers for child support and spousal support.
Yeah, I mean, I think it is. It's cautious. It's the first thing, and a lawyer is going to do is to see, what you're paying out of your business, count it as personal income. You can't double dip, obviously. I think be transparent with your lawyer. Let the lawyer sort it out. I think that's the best way to move forward. Dorothy, Ohio question. Marty wants to know, after our divorce, my wife moved one state over to live with her parents. We have split custody, and that has been working out so far. But next school year, she says she wants the kids to move with her and their grandparents full-time during the week and go to a new school. The school over there isn't where they would be comfortable. And the school that they go to now is by my house, is what they know, and they have friends. Really, the question becomes, what are Marty's options?
Sure. So Marty, the first thing you have to do is pull out your decree. Definitely in Ohio, it would indicate who is the primary residential parent for educational purposes, or alternatively, it would indicate a school district which was agreed upon and ordered. That will control. If she would like to move them to the school in the new state, then she would have to file a modification to change her underlying decree. And at that point, the court would be looking at best interests. And it's back to the point you've raised in your question. Where do they feel comfortable? How long have they been there? Are they excelling? Are they doing well? Her choice to move doesn't sound like it's based on the best interest of the children, but perhaps convenience for her, which is not going to be compelling to the court.
I think, Marty, taking action sooner than later, again, always paper trail. We always want to communicate and have evidence in writing that suggests she's trying to change the school address for the children and whatever that district is, and file an action in opposition. And now you have a competing interest where you may have experts. Imagine that. We're tying it into today's case. You may have an expert who testifies about the school districts between each two and what's better and what's more appropriate. But paper trail first, have a consultation with a lawyer, put together a strategy, decide whether or not you need to file. So that is all the time we have for our virtual town hall for February. Thanks for joining. Continue to do that. Send us your questions via email at townhalls@cordelllaw.com. Townhalls@cordelllaw.com. Check out the YouTube channel where our virtual town hall will be posted for replay, as well as all the others and the podcasts that have been done over the last year will continue. Check out our town hall coming up in March. Listen to our podcast twice each week. You can subscribe online through Apple or through other to make sure you get the updates and when they're doing. And we're just talking about topics just like this, and we'll get you answers. So again, register for the March. We look forward to seeing you next time. And so until then, have a great week.